This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we talk about why an insurer's attempt to obtain summary judgment against fraud perpetrators failed, because to prove fraud, admissible evidence is required, and allegations of healthcare providers assisting no-fault fraud escape the insurer's motion for summary judgment, but do not escape trial. In a case entitled Nationwide General Insurance Company et al. And any of their subsidiaries against BILLEESHA Brown, MANUEL A, CRUZ, ANGELIS TATIS et al., the Supreme Court of New York, Nassau County, on September 15, 2025, dealt with a motion for summary judgment filed by the insurer. The declaratory action filed by the insurers sought a determination that it is not obligated to provide first-party automobile insurance coverage, including no-fault benefits or uninsured or underinsured motorist benefits, in connection with a motor vehicle collision alleged to have occurred on August 7, 2022. The incident involved a nationwide insured vehicle driven by BILLEESHA Brown with passengers Manuel A, CRUZ and ALGELIS TATIS. The vehicle was reportedly struck in the left rear by a hit-and-run vehicle, causing Brown to lose control and hit the highway divider. The plaintiff argued that the individual defendants staged and/or intentionally caused the collision and made material misrepresentations and/or omissions of fact and false and/or fraudulent statements in presenting their claims to Nationwide. The plaintiff relied on the discrepancies in Brown's representations and easy pass records to suggest that the individual defendants were not in the insured vehicle at the time of the incident. The court found that the discrepancies raised suspicion, but were not sufficient to establish as a matter of law that the individual defendants made material misrepresentations about their presence in the vehicle. The court also noted that an intentional and staged collision caused in furtherance of an insurance fraud scheme is not a covered accident under a policy of insurance. The court referenced several legal precedents to articulate the standard of proof required for summary judgment. The court emphasized that the plaintiff must demonstrate prima facie entitlement to judgment as a matter of law and the absence of any issues of material fact. The court denied the plaintiff's motion for summary judgment, finding that the plaintiff failed to meet the higher burden of proof required for such a motion. The court acknowledged that on plaintiff's prior motion for a default judgment, the court found plaintiff's prima facie proof sufficient for purposes of granting the motion. On a motion for a default judgment, however, the defaulting defendants are deemed to have admitted all of the allegations of the complaint and all reasonable inferences to be drawn from them, and the plaintiff's heed only establish that a viable cause of action existed. The standard of proof applicable upon a motion for summary judgment seeking a determination that the insurer is not required to pay no-fault claims submitted by provider defendants has been articulated consistently and is controlling authority for any determination by this particular court. It found that it was well settled that an intentional and staged collision caused in furtherance of an insurance fraud scheme is not a covered accident under a policy of insurance. The court's analysis of the evidence, however, as it pertained to the issues of intentional nature of the occurrence or the fraudulent presentation of the claim, is set forth in the entire summary judgment motion and need not be repeated by the court in its opinion. As stated by the court in the summary judgment decision, most of the alleged discrepancies in the examination under oath testimony of the individual defendants were not material to the claim that the incident was intentional or conclusive of a material misrepresentation in the presentation of the claim. The Easy Pass records only demonstrate the location of the second vehicle on the night in question. They do not establish who occupied the second vehicle or that the individual defendants did not occupy the subject vehicle. Plaintiff's investigator makes an inferential leap that is and was unsupported by admissible proof. Without more, the evidence presented raises issues of fact or credibility, which are appropriately determined by the trier of fact at a trial, and the motion for summary judgment was therefore rejected. Nationwide, like other no-fault insurers doing business in New York, lose much money as a result of fraud and staged accidents, and fight back by suing those who staged the accidents and the healthcare providers of the fake treatment of non-injured fraudsters. Nationwide proves some of the fraud because the defendants defaulted, but will need to produce more evidence of fraud at trial that is more than an unsupported inferential leap of fact by its investigators. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. You can subscribe to the blog, and if you do, you'll receive notice of every blog posting, usually 5, sometimes 6 a week. And you'll also gain access to the more than 5,200 blog postings. Please tell your friends and colleagues about this blog so that they too can subscribe to the blog and the videos on YouTube or rumble.com. They're free. And if you're interested in further detail about insurance, insurance claims, insurance law, and insurance fraud, please consider, for a very small fee, subscribing to my Substack publication. Thank you for your attention.